Welcome back to another Senior Learning Institute's educational moment, where older adults and their loved ones turn for honest and straightforward information. In just a few minutes, you'll enjoy bite-sized, easily digestible nuggets of knowledge, empowering you to make the right decision the first time. So without further ado, here's our founder, certified senior advisor, seniors real estate specialist, nationally syndicated podcaster and speaker, the advocate you can trust, Mr. Ted Gottlieb.
In order to make sure that everyone is on the same page and that everyone understands, our wishes need to be in writing. This is especially true when it comes to making healthcare decisions. This Senior Learning Institute educational moment addresses healthcare power of attorneys and HIPAA releases. Shawn Estep is back, so thank you. Shawn is an estate planning attorney, elder law attorney, principal of the Estep Law Firm, member of the National Academy of Elder Law Attorneys, and proud sponsor of the 2020 Senior Learning Institute Seminar Series. Shawn, for those who did not hear our initial conversation on power of attorneys, can you summarize for us what they are and why they are so important as part of an estate plan?
Sure. So powers of attorney are a person called the principal's instruction to someone else. Typically that person's called either an agent or attorney in fact, instructions on how to manage either their finances or their health care if they cannot. All right, so when we start with healthcare powers, I think of healthcare powers as a three-piece kind of a deal. It's a power of attorney for healthcare. It's a HIPAA release, and it's a declaration and medical directive, or sometimes it's called advanced directive or living will. So it's really three tools in your kit for healthcare decision making.
Okay. One of the things we also touched on last time we spoke is that in most cases, these POAs or power of attorneys and releases are only in effect while a person who appoints the power of attorney is still alive. Is that correct?
That is correct. The only document that really survives a person who has passed away is the HIPAA release. And we typically will have those continue for up to 5 years after the person's died, simply because we want our person who's a personal representative or a trustee to be able to get access to protected healthcare information after that person's died, either for administration purposes or if there was some sort of a lawsuit involved in the death, we want them to be able to get access for that purpose. But otherwise, the other documents do stop at the death of the principal.
Got it. All right, so then let's focus on the healthcare power of attorney. Shawn, tell us what it does, what it can't do, and when it's effective.
Okay, great. So power of attorney for healthcare is a document that allows your agent or attorney in fact to make day-to-day decisions about your medications, treatments, caregivers, doctors, what hospital you might go to, and also what nursing home you might go to. So that's kind of the powers that it has. The powers it does not have. You cannot manage finances with it. Okay. In conjunction with your declaration and medical directive, or in conjunction with your living will or advanced directive, it allows your attorney in fact to make day-to-day decisions about end of life. So for instance, things like removing you from life support. And again, we'll talk about that in a few minutes, obviously, but that's what that power of attorney can do and what it cannot do.
Okay, so if we have a healthcare power of attorney, why do we need this HIPAA release?
Because the power of attorney itself does not, unless it's included in the power, give that person authority to get access to your protected healthcare information. So there are two ways for that HIPAA release to work. It can either be integral to your or included in your power of attorney for healthcare, okay, which is often the case if you just get the power of attorney for healthcare, or it can be part of your overall estate plan where that HIPAA release is used by your trustee under your trust, by your personal representative under a will, by your attorney in fact under powers of attorney for finance. So in that case, we have separate HIPAA releases because all those people may be different. So we want them to all have access to that healthcare information for different reasons.
Right. So this can get, I don't want to use the word complicated, but there's a lot of moving parts here, and that's why we talk about really sitting down and going over
Right.
Everything that needs to be taken care of, short-term, long-term, and have a plan in place. And that's why I love putting together teams of the financial advisors and estate planning attorneys, everybody else, so that we're all on the same page, so
Right.
that we know exactly what needs to be in place for whatever purposes. You had mentioned something about end-of-life care and those difficult decisions. Why don't you elaborate on that a little bit more in regard to how we can make sure that those wishes are known and communicated to our POA?
Okay, good. So the way that works is that I use what's called a declaration and medical directive. Those are two separate documents. Let's talk about the declaration first. The declaration is actually a statutory piece of the end-of-life puzzle. It in essence says, I am in a persistent vegetative state. I'm dying. I'm connected to life-supporting monitors and so forth. And that's all that's keeping me alive. My prognosis is not for a long life. So I want my attorney in fact for healthcare to remove all life support and allow me to die naturally. So that's the purpose of that. So the person, again, that makes that decision is your attorney in fact under your power of attorney for healthcare. And that's an instruction by you to them. It's not a power in and of itself. It requires that power of attorney for healthcare for that declaration to work. Okay. The second document is your medical directive. So there are procedures that physicians like to use to treat people. Things like heart-lung machines or invasive surgical procedures or radiation therapies or chemotherapies that maybe marginally are going to make a difference, but you want your family members to know that if it's marginally making a difference or if it's making no difference at all, that they should have the ability to withdraw or withhold. Again, it's not a power, it's simply your suggestion to your attorney in fact for healthcare that you don't want those extraordinary measures if they've determined, again, that you can't make the decision yourself. It's not improving your life. You're not going to become more comfortable. It's not going to change your prognosis. You're still dying. It gives them the ability to withdraw or withhold those extraordinary procedures. There's one that actually says, I want to die at home. So it's kind of a little different, but it gives your attorney in fact the ability to remove you from a hospital and allow you to die at home, either on hospice or however that's going to work for you in your personal situation.
Right. So how do I know that my wishes are going to be actually kept? So I might want something and then my POA decides they want something else. Is there a way that I can make sure that that doesn't happen?
Not really, unless you just choose the right people. And if your choices for healthcare are um, not being respected, you can, or at least your other family members can remove that person. But again, you get in a situation where you're fighting over this person, and that might be a situation where you end up in court and a family member decides that they want to be guardian over your person and make those healthcare decisions on your behalf because the person that is your attorney in fact for healthcare, they don't feel like is making the right decision. So now you've entered the court situation, which our hope is that you choose the right people, that we don't have family dynamics cause issues, but there are no guarantees. But at least with the powers of attorney for healthcare and also with powers of attorney for finance, at least you've given your family the best opportunity to avoid litigation and make sure your choices are continued. That what you want to have happen happens. It's your best chance to control your healthcare.
Right. And that's really the whole purpose behind this, I guess, is to hopefully help maintain a positive family dynamic. And also, I think, to take the burden of this decision making off of your of your kids or your loved ones or whoever else you choose to have
It
them.
absolutely does that. You're right, Ted. It absolutely does that. So instead of the family trying to figure out who's going to be speaking for you, you've told them. You've again given them kind of a sense of relief that they don't have to try and figure out who's going to speak for you. And my goal for you is to make sure you've had that conversation with your family already, that this isn't a surprise to them, that they know what your wishes are. If it's a surprise, it can certainly become a difficult family dynamic. So again, it's better to have the conversation up front, let people know what their roles are. I do seminars and webinars on this all the time, so that people know what their roles are and why their parents have chosen them for these particular roles.
Right. And I've been in conversations with attorneys and clients and kids where, the attorney really brokered that whole conversation and said, this is what our wishes, this is what mom and dad's wishes are. I want to make sure that you're aware of it. Do you have any questions? And really help have that difficult conversation. So that's a gift that I know you can give on occasion. Let me ask you this, Shawn, what does it take if I want to move forward and put a HIPAA release together, or a healthcare or financial power of attorney? What does it take to get that going?
Typically, what we're going to ask you to do is decide what you're trying to accomplish. So usually when my clients come into the office, they're there for a comprehensive estate plan. So that's going to be either a will-based estate plan or it's going to be a trust-based estate plan. On a rare occasion, I'll have clients that just want powers of attorney for finance or powers of attorney for healthcare, or a simple package just for powers of attorney. In any case, what we're going to ask them to do is fill out a questionnaire. It's going to ask who the people are that are their family members. And then at some point, we're going to have a conversation. And we're going to want to know what are the things that are important to them, especially from a financial and a healthcare position. What can we do to help them out? What are the things we need to make sure are in this power of attorney for finance, power of attorney for healthcare? Is there a need to do more advanced planning as part of that conversation? And the answer can be no, but we want to make sure we've covered those bases, make sure we give them an opportunity to control as much as possible.
Got it. You had mentioned last time that we spoke too that you have electronic copies of these documents, and you also make paper copies available to the clients and whoever else they want to have copies to. So that's awesome.
Well, not only that, but here's something we offer in our firm. Because sometimes you're going to be in an emergency room situation, or you're going to be on travel somewhere and you don't have access to your healthcare information. You may be in an emergency room in California and you don't have, or your physician won't have access to, what your pre-existing conditions are, who your primary physician is. They won't have access to your powers of attorney for healthcare, your HIPAA release, and your declaration of medical directive. And if you can't tell them what that information is, how are they going to treat you properly? So we have an emergency healthcare card that gives them access either through the internet or by fax for that kind of information. So pre-existing conditions, allergies, who the primary physician is, who your emergency contacts are. And they can also download powers of attorney for healthcare, the HIPAA release, and the declaration and medical directive. Those are all things that as they need them, they can download. So again, if you can't speak for yourself, you have this card that gives access to emergency room personnel, or even, in fact, for your spouse, so that they can make decisions while you're in an emergency room and don't have those documents with you.
Oh, that's great. That's an awesome tool. But you just opened up a Pandora's box in my mind, only in the fact that you had said you give a great example. Let's say you're living in Missouri and you go to California. Are these documents universal, or do they differ from state to state? How do I know that it's going to be honored in California if I'm from Missouri?
Well, they differ from state to state, obviously, but what most medical communities try to do is honor to the greatest extent possible what that person is asking. So if you're in California, and you're injured and you want your husband or you want a daughter or son to make healthcare decisions for you, to the extent possible, that hospital is going to allow that, especially if there's written instructions that they see. They certainly don't want to do something that's not in your best interest. And they want to give you and your family the greatest amount of decision-making authority as possible. Now, there's some exceptions to that, obviously. I've heard stories about hospitals that will set your family down. They'll have 7 or 8 doctors saying, hey, we need to do this to mom or dad. And the family says, no, mom and dad, they're done. And the hospital just really wants them to do this. But at the end of the day, they will respect the family's wishes if they are written down, if they're very clear. You always have that opportunity if needed to complain, but hopefully the physicians are in a situation where they just want to make sure that they're covered, that there's a power of attorney. Yeah, it's from Missouri. Yeah, we're in California. Some of this may not be exactly what California allows, but we're going to allow as much of it as we can.
Oh, that's great. So, Shawn, I want to thank you so much for the information and your insight. If someone wants to connect with you, what's the best way for them to do that?
The first and most easiest way, I suppose, is to give me a call. You can reach me at 636-233-2017. You can also reach us at our website. That's www.esteplawfirm.com.
That's great. Hey, I want to ask you this too, because I do something in regard to helping folks nationally in regard to buying and selling real estate, because I'm in a network of sorts of top producing folks who can, nationwide, who can help get homes sold. So I can refer. Is that something that you can do as well as being part of?
Absolutely.
NALA?
I have colleagues all over the country. In fact, I've had families move to Arkansas, California, New York, and we've connected them with attorneys that practice law in the same fashion that I do. They're very education oriented. They're very counseling oriented. They care for their clients, and they do the best job they can. They retain documents the same way we do. So again, we have thousands of attorneys across the country that I'm connected with through a network that we can, again, get them connected with, and they would be comfortable in that environment.
Yeah, it sure helps when you have somebody who can pre-qualify other folks in your marketplace and make sure that things are going to be done right. So it's better than a shot in the dark for sure. I want to thank the audience for listening to this Senior Learning Institute educational moment. At the Senior Learning Institute, we strive to provide straightforward and unbiased information to help you make smart decisions. The first time is a totally free service. We really are here to connect you. That's our mandate. So we really are here to connect older adults and their advocates to the resources they need, from, gosh, you name it, from staying put to estate and financial planning, care management, estate sales, clean out services, even maintaining the home, and also selling the home for as much as possible, no matter its condition, anywhere throughout the United States. To learn more, please visit us at theseniorlearninginstitute.com. Until next time, I'm Ted Gottlieb, Certified Senior Advisor, Seniors Real Estate Specialist, and founder of the Senior Learning Institute.